And welcome back to our continuing coverage of James Crumbley heading to trial again on 4 counts of involuntary manslaughter. And he is the father of the Oxford High School shooter. So we had some pretrial motions today in Oakland County Circuit Court. Judge Cheryl Matthews talking about who can or cannot testify. She's still deciding about 2 specific witnesses, students that were in the 200 hallway and were wounded in the shooting back on November 30th of 2021. But there are also several other questions that are hanging out there about things that could be put into evidence. And for that, I want to bring in Cassidy John Cox. She writes on clickondetroit.com, and anything that you have been reading about the Crumbley trials, she has been writing it. So Cassidy, it's great to see you as we watch this hearing together this morning.
Thanks for having me, Christy.
All right, so this happened at just after 11 o'clock this morning. We were expecting some other things maybe to come in play, and I want to start off with the change of venue. We have been talking about, the defense has put it in motion saying, hey, James Crumbley cannot get a fair trial thanks to all of the media coverage from his wife Jennifer's trial just a couple of weeks ago. But you've been talking to some legal experts about how difficult a change of venue can be.
Yeah, it's not an easy task to achieve because a court is assigned a case for a very specific reason. The court has jurisdiction over the person or property that was involved in the crime. And so in order to move this out of Oakland County, where the shooting took place, where the defendant lives, it would be a difficult sell to try to get it elsewhere.
So the judge will have to take that into consideration. And again, Cassidy, I mean, talk a little bit about the process of even picking a jury. We saw it play out with Jennifer's case, and it will play out the same way starting March 5th. For James' case, they're going to bring in a huge pool of potential jurors, and they get to go through and question them, and it's called voir dire, where they can ask certain things saying, can you be impartial, and just look at the evidence in front of you.
Yeah, absolutely. That's the biggest concern for the defendant here, is he wants to ensure that he has an impartial jury. And so he believes that because of this pretrial media coverage that it might be difficult to secure a jury that is, unfamiliar with the case or doesn't have any prejudice against him. And so, but the prosecutors say, yes, exactly, that questioning that they went through during Jennifer Crumbley's jury selection really helped ensure that they had jurors who were willing to hear the case and hear the facts and decide for themselves whether they, wanted to convict Jennifer Crumbley or not, ignoring the media coverage that had been out there previously. So the defense is really trying to push here and say, we want to make sure we're going to go elsewhere, but prosecutors say that that might be, there's just no point, really.
Yeah, and I mean, attorneys are telling me, where can you go that no one has heard of this case? Because again, when we talk about it being historic in nature, it's the first time that parents have been criminally held responsible for a child's action in a school shooting like this. So again, this is international news. Let's go to the next 2 things that the judge is going to be looking at that both sides are going to argue for. So the defense does not want to put into evidence text messages that the shooter went back and forth with a friend talking about his mental state. Now, we saw these messages actually come into play in Jennifer's trial.
That's right. The defense here is taking a different approach and ensuring that this information that was written by the shooter doesn't come into the trial, because the shooter has said he will not take the stand. And so for him to not take the stand, that means the defense has no opportunity to cross-examine this exact testimony. And so they're trying to say this is not related to James Crumbley because he didn't see this information. And so it's incorrect. It's improper to allow it into court if he's not allowed to, if his defense is not allowed to cross-examine it.
Yeah, I did speak with George Danini, and he's a criminal defense attorney from Butzel, about a lot of aspects of this case. And we did zero in on those text messages because it's the one time that we see James Crumbley being mentioned by the shooter saying, I asked my dad to take me to a doctor, and he said, suck it up, and told me to take some pills. Let's go ahead and take a listen to what George has to say about that coming into play. The one thing that sticks out to me is a damaging text that the shooter actually sent to a friend saying, I asked for help from my dad, and he said to take some pills and to suck it up. The defense, no one can cross-examine the shooter on those text messages, but we saw them come through in Jennifer's trial.
Yeah, so whether they'll come in, or in this case, just again, because it came in there doesn't mean it's going to come in here. And so there's all kinds of evidentiary rules that are out there to determine whether something should come in. That'll be up to the judge. Yeah, and it's a problem. If something like that comes in, you can't cross-examine a piece of paper. And so if the shooter doesn't testify, and obviously he didn't testify in the mother's trial, again, doesn't 100% mean he wouldn't hear, but but I don't imagine his lawyers are going to change their position that, he would assert his Fifth Amendment rights, et cetera. I think they're appealing, so I don't anticipate that he would testify here. But it complicates it. If that comes in, how do you rebut it?
So then thinking about evidence that comes in, again, the journal that the shooter kept and writing the night before saying that he was going to shoot up the school. People might be confused as to why that's allowed to be in a case like this. It was in Jennifer's.
Yeah, so these are statements that were kind of, I guess you can call it in furtherance of the crime, and so they're likely to come in again in this trial. It kind of forms the foundation of what happened. I think that part of the responses by James Crumbley's lawyer will be that he never saw those things. He saw some of them, but if there were some musings, I think you just said he asked for help and basically take a pill and suck it up. Mm-hmm. Just because that's written down doesn't mean he actually said it. And if the father never saw that, it could just be the shooter saying those things, but it doesn't mean it happened.
And Cassidy, George really talks about what the path of the defense attorney is saying, and we're talking about the third thing that they don't want in is the journal that the shooter wrote in saying, I'm going to shoot up the school. I haven't gotten any help for my mental problems. And George making the point, well, if the parents didn't see that, and the defense saying, look, and if we can't cross-examine, and we see the journal that was put into evidence in Jennifer Crumbley's case. These are some really interesting legal questions that is coming up in this case that already passed through for Jennifer's case.
Yeah, definitely. And this is a really interesting, it's kind of interesting to see how this differs from Jennifer Crumbley's case, and that the defense is really focusing on the fact that this should not be brought into court in their opinion because it can't be cross-examined, right? And so without this evidence, the case kind of changes for James Crumbley here because there are a lot of technical aspects to proving involuntary manslaughter in the legal sense. But essentially, the jury will be considering whether James Crumbley could have foreseen this crime. Was there information that he knew that he failed to act on that could have prevented this crime? And having that journal excluded and having that, that evidence that really kind of helps pin him on this, it would be really interesting to see how that plays out in court.
Exactly, and we did hear from the jury forewoman in Jennifer's case saying the journal was a pretty instrumental thing for the jury to take into consideration, that it was pretty important. So it'll be interesting to see how the judge rules on this one. Of course, Rod talking about, we're going to be hearing more on that on the 28th next week. But one thing that's also really interesting, Cassidy, is we did hear from James Crumbley himself this morning. It was more procedural, but anytime that you can hear from a criminal defendant talking back and forth with the judge, it's always just kind of interesting to hear because we haven't heard much from James Crumbley in all of this time. But it was more procedural, just understanding that his defense attorney he used to be a co-defendant or a joint defendant with his wife, but now they're separate and they have separate representation.
Yeah, exactly. This is the first time we've seen James Crumbley in a while, actually. So to hear him in court today was interesting. And yes, the judge is making sure that the defense and the defendant, everybody is all on the same page about what is happening here to ensure that there is absolutely no chance for a mistrial going forward. And that's really the reason why she's taking every single step that she can to make sure that the defendant is aware of his position, what's happening, what's being brought against him, and his role in all of it.
All right, Cassidy Johncox from clickondetroit.com, and you can read everything that she is writing surrounding the Crumbley trial. Of course, just check her out there. Appreciate your expertise on this one, Cassidy. We'll see you in just a little bit. All right, if you missed any of the hearing, we are going to go back at 1 o'clock today, and we're going to have some of that for you. We'll also have our weather forecast for the week for you. So stay with us. We will be right back.